Unfortunately, a fairly common occurrence is we have surviving spouses or surviving children come to us because their parent or grandparent or uncle um, have passed and there is no will or there is no estate plan in place. Now, these types of situations, while fairly common, they are directed by specific rules in the probate process, and those rules are also varied from state to state. Here in South Carolina, if somebody dies without a will or an estate plan, the term is called they pass intestacy. That means without the will or estate. If somebody dies intestate, then the first place that they look for distributing the assets goes to if there is a surviving spouse. Once the surviving spouse receives their portion of the assets in the person who's pass's name, then they begin to look at the family tree in order to determine where the remainder of the assets go. The first place that they would look would be if there's any surviving children. If there aren't any children, they may look at grandchildren, parents, grandparents, even brothers or sisters. They really would look at the closest living relative in order to determine who is the heir to the estate. The problem with that is that once these heirs are determined, then everything in the estate is divided up and distributed amongst those people. If you don't have a will or if you don't have an estate plan, then you have no control, or any other surviving heirs have no control over who gets what. It's all based on closest living relatives.